Hello and welcome to the latest episode of Mayor Brown's video series at the Crossroads, CFTC and DOJ enforcement. My name's Matt Kluchenek, partner at Mayor Brown, a member of Mayor Brown's litigation and dispute resolution group, and I'm joined today by my partner, Glen Kopp, a former federal prosecutor from the Southern District of New York, a partner at Mayor Brown, and a member of Mayor Brown's white-collar defense team. As you know, each week we seek to bring to you an interesting topic regarding CFTC and DOJ enforcement. And today we think we have another interesting one, and that is with respect to extradition. Glenn, let me turn it over to you at this stage.
Thanks, Matt. So in previous discussions, we've talked about the sort of global reach of the DOJ and the CFTC and jurisdictional issues. We've also talked about the tools that the DOJ and the CFTC have in terms of obtaining evidence abroad in connection with global investigations. And so today, as you mentioned, Matt, we're going to talk about extradition. So the process that the US government goes through to try to bring defendants who are abroad into the US for prosecution, or at times also for sentencing. Could be an extradition of someone who's previously been convicted. And so, Matt, I guess the first question is back to you, is why do we care about extraditions in the context of futures and derivatives trading for folks abroad?
Thanks, Glenn. So at least initially to table set, we've seen over the last several years a substantial increase in cross-border enforcement. We've discussed that a little bit in the past on some of these video series, but really the notion of the CFTC in particular, reaching out beyond the United States, whether it's in Asia or Europe, where there are so many active traders, active derivatives market participants, and focusing extensive efforts on trying to ferret out wrongdoing committed in those jurisdictions on US futures markets or swap markets, whatever the case may be. So there's been just a really, really significant increase. And then coupled with that, as we've discussed before, cross-border enforcement, where the CFTC teams up with regulators in other jurisdictions. You know, typically, as you know, they rely upon MOUs with respect to enforcement efforts. But when we get into issues involving the DOJ and potential criminality, and so forth, and this issue of extradition, it's really an issue that's not germane to the CFTC world, which can compel via subpoena, and again, working through other regulators. But extradition, it's an issue that's popped up recently in the past in connection with the Navinder Saroo matter, and it's potentially an issue with respect to anyone sitting outside the United States who is under the microscope with respect to the DOJ and trading conduct. So with that kind of, again, broad sort of foundational overview, Glenn, just first steps here, tell us a little bit, what is extradition and when does it become relevant?
Sure. So extradition, the process of having someone from who's located in another country arrested and then sent over to the US to face charges or again to be sentenced, is a process that's governed by a bilateral treaty between the US and another country, similar to the way the mutual legal assistance treaties operate. And here, typically there are two types of treaties, I guess. You could categorize those that might list within the countries what are the specific offenses that are extraditable, and you'll have reciprocity within the treaties for each country. But also there's this sort of more general proposition that what is conduct that is generally a crime in each country or qualifies as a crime in each country, and usually for which there's at least a 12-month potential criminal sentence, a prison sentence, that will be an extraditable offense. And so,
Glenn, just a quick question there, if I may. So is spoofing typically one of those delineated offenses?
No, and we'll get into those details, Matt, but no, and that's not, however, preclusive, because if spoofing as defined, or the conduct in particular that underlies that spoofing claim can be a crime in the country other than the US, the country from which you're trying to extradite, that could be an extraditable offense. And in fact, that was something that was litigated in the Navinder Sarao case that you mentioned, which was sort of famous for its alleged ties to the 2010 flash crash. So no, it doesn't have to be a specifically delineated crime or a title, a similar title like spoofing in each country. That's not the analysis necessarily. It's whether or not that conduct could be determined to be a crime within that country. And so the way we get to that point that that's being litigated is that in the US, the US prosecutor, if there are charges for which they want someone who's abroad to face in the US, what the prosecutor will do is they'll put together a package. And that package will contain an affidavit from the prosecutor sworn out in court that will essentially summarize the facts of the case, the procedural history of the case, as well as the relevant statutes. They'll put that together with copies of those statutes, copy of the relevant paperwork, whether it's the arrest warrant, a complaint or an indictment that was filed in the case, as well as supporting affidavits and some documentary evidence, because the key here is that you have to have probable cause, right? That the defendant, that particular defendant is the person who committed the alleged offense. And so that will be reviewed by the country that is receiving that request. So you've got to have all that in the package, as well as at times a translation of all that material into the local language. All that information will then be provided to the Office of International Affairs in the US. It will then review it. That office will review the material to make sure that it's sufficient and meets all the requirements of the extradition treaty. The State Department also gets a view because ultimately the executive branch of each country has a role to play here. And ultimately, if the State Department approves it, the package then gets sent over to its counterpart in the recipient country from which the extradition is being requested. And then if it's approved, an arrest warrant would be issued, the person would be arrested. And then at that point, we talked about the challenge, like spoofing, right? Whether that's an extraditable offense. At that point, the person who is arrested in their home country, or could be a foreign citizen in another country, at that point, they can then challenge the extradition. And they'll first challenge that judicially, usually in front of a court that will be making rulings as to whether or not the extradition is proper under the treaty, as well as under their own local laws for extradition.
And so one of these challenges, dual criminality, right? The notion that it's a crime in the United States, but it's also a crime in the UK or Singapore or Japan, whatever jurisdiction we're talking about. Is that, Glenn, one of the more, maybe discuss that a little bit? Is that one of the more common types of challenges?
Yeah, it absolutely is, Matt. And to put it in context, you saw that in the Sarao case, where the challenge was to the fact of challenges spoofing, right? Is spoofing or the conduct that underlies relevant charges like spoofing or commodities fraud or wire fraud, would that be a crime in the UK? And Sarao argued it wasn't to the extradition courts. And the courts rejected that decision. He challenged it on appeal. It was upheld on appeal, and ultimately he was extradited. And there, what the court looked at is they looked at relevant fraud statutes in the UK to determine whether or not spoofing would be, or the conduct that was alleged for Sarao, whether that would suffice under the relevant statutes in the UK. And ultimately the court found, yes, it does, under the Fraud Act of 2006, the Financial Services and Markets Act of 2000, as well as the Financial Services Act of 2012. The court found that all three of those statutory regimes had provisions that would meet the conduct for Sarao as alleged. And basically what that conduct was, right, is placing bids or orders that would, with the intent not to have them filled or to cancel them. And so that's a common challenge. You also see challenges, Matt, to probable cause, which makes sense, right? If there's no probable cause, there shouldn't have been arrest warrant, shouldn't be an extradition request. There's also something called the political offense doctrine. And there, a defendant might say, look, the US is only coming after me because I offended them politically. I supported an opposition party, or I have made negative comments about the current government. And so this is a political offense. And just like the US wouldn't extradite for that, you, recipient country, shouldn't extradite me for that. And we have a recent example there of McAfee, who's a defendant in a commodities case that we talked about, a market manipulation case. He is challenging actually extradition from Spain on the grounds that he's got some related tax, or he's got tax charges that he's fighting there. And his claim is that his extradition and arrest is being sought by the US because he supported a opposition candidate in the 2020 election. And so that's another grounds for which people will seek to fight extradition.
Hey, Glenn, what about this challenge, interest of justice as a challenge? Sounds really broad and somewhat vague, but it has some meat behind it, right? And there's been some litigation around this.
Yeah, actually in the UK recently, there was a case in relation to some foreign exchange trade prosecution by the US of former HSBC bankers. And there, what you have is sort of, it's almost like a fairness challenge. Is it fair to have this prosecution take place in the requesting country, like there at the US? And there's a number of factors that the court in the UK looked at, but in essence, what they said for the defendant who is challenging extradition there, Stuart Scott, and I'll read from the court's opinion, what they said is there are two powerful factors against extradition, namely the fact that most of the harm took place in this jurisdiction, meaning the UK, and that the appellant's strong connection, meaning Scott's connection, in or with the United Kingdom and absence of any significant connection with the US was in favor or weighed against extradition there. So it's sort of, where's the evidence? Where's the crime take place? Where are the victims? You look at all those things and you say, where should this prosecution take place? Now, interestingly enough, the UK government had determined not to prosecute Scott for that alleged crime. So ultimately, he's not being prosecuted right now. Doesn't mean everything's over. Arrest warrants or Interpol notices for arrests from other countries that the US has relationships with could happen if Scott was to ever leave the UK. But for now, he's not being extradited. That matter is done in the UK. So that sort of interest of justice defense can be used and is something that should be considered when you're facing extradition, if that is a defense under the treaty or the laws of that particular country in which you're located.
So big win for Mr. Scott with respect to extradition. Okay, so takeaways, Glenn. I mean, we know from a criminal perspective, if you're sitting outside the U.S. And there's an extradition request, obviously something you need to take seriously. Part of the calculus. No assumptions to be had here. It's going to be tailored, presumably, with respect to each jurisdiction and whether there's a treaty and what that provides, and so on and so forth. Glenn, in terms of the role of counsel in respect of all of this?
I think it's essential, Matt. If you do come under the impression that you're a target of extradition, once you know that that's coming down the pike, I think it's essential to get counsel to advise you, because there are a number of ways to deal with it. It being extradition, you can always waive extradition. You can voluntarily come to the US and face charges. And there's a calculus that you need to make and whether or not that makes the most sense for you. I think we've seen in the Vorley and Chanu case, the Deutsche Bank traders who were convicted recently for spoofing related charges, they both sought to voluntarily surrender and waive extradition. And now you're seeing that tool being used, even though they were convicted, you're seeing them use that fact to try to get lesser sentences. You can use that fact to avoid pre-conviction jail time, right? You don't want to be sitting in jail while your case is being litigated. And so if you're willing to waive extradition, you're not necessarily going to be in jail much in your local country. And when you come to the US, it's a pretty powerful argument for bail. is that you're willing to come and face the charges. So it's a pretty powerful argument that you're willing to show up in court the next time around and continue to show up in court. So you want to have those discussions with your lawyer and then go through whatever arguments you might potentially have against extradition and whether or not you're going to challenge that in your local jurisdiction in your local country. So really, really, really important to make sure you're conversing and conferring with counsel if you do come under potential extradition.
Great. All right. Thanks, Glenn. And this concludes our episode of At the Crossroads. Thanks to everyone for watching, and we look forward to seeing you next week. Thanks.